Welcome to Court Beyond, where real courtroom justice unfolds before your eyes. In today's episode, we start with a defendant facing serious consequences for sex offender registration violations and repeated probation violations in Texas court. Despite initially complying, the individual stopped reporting as required, defying court orders and failing to meet the conditions set by the Texas Department of Corrections, as emphasized by Judge Raquel West. The criminal history spans multiple felony offenses, including assault, sexual offenses, and prior probation revocation. Judge Raquel West carefully reviews each missed report and probation failure, highlighting the serious consequences of failing to comply with sex offender registration and breaking probation rules in Texas. Let's dive into the video and see how the courtroom drama unfolds.
Good morning. You're Lenton Arseno. And Mr. Arseno, are you currently sick?
Ma'am?
Are you sick right now?
No.
Would you pull that down for me just so there you go, I can hear you better in the hearing. And Mr. Arseno, in cause number 24, DCCR 2190, was previously in court, entered a plea of guilty to failure to comply with sex offender registration requirements. The agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor. Nothing to attach.
All right, Mr. LeBlanc, you may proceed.
Judge, reading this PSI report, it does appear that he has a lengthy criminal history. I would say the top part of that had a lot to do with him being homeless at the time, the criminal trespasses that were all dismissed, all those. It looks, defense lawyer can't look worse than it. I've seen worse. Although he does have some extensive history. This case that he has to, the reason he has to report was from a case in 2023 that evidently he got the minimum 2 years, and I wasn't part of that case. He got the minimum on a, and I don't think he went to penitentiary. He stayed in county jail on that. That's my understanding, Judge. And I'm not making light.
On that case, he did, yes.
And in this case, Judge, I watched the video that he did go in and try to report. I don't think he went back the next year is what it was. I think he reported initially.
I brought everything in myself.
And I watched the interview and it was confusing to me as to what he had to do. And I don't know, I think he probably just got frustrated and just didn't go the next year. And that's wrong. And that's what we're here before the court for. It's been capped, and I appreciate the prosecutor doing that. I would ask the court to sentencing towards the lower end, Judge. I don't think 10 years, 10 years is a long time for him not reporting for that. So Judge, I would ask that you consider, he doesn't want a trial, he doesn't want probation. He said that he was upfront with the court. Probation's not an option in his mind, and he's ready to do his time, whatever the court deems is fair.
All right, thank you. Mr.
I
Hoffbauer?
want to direct the court to page 1 of the PSI, really it's page 2, but to the defendant's version, I don't believe that he's taking responsibility for it. He says, I think that's a hedge. That's not I did it, and he said he wasn't told somehow. He knew he had a report. He did, but he did initially, but then didn't. I'm not really sure what the court thinks of that. I know what I think of that is that it's a hedge and that he thinks that he gets to decide whether he reports or he doesn't. I don't care how long he got initially. This is part of being a sex offender is reporting. We need to know where you're at. And if you aren't, then you're supervising yourself, and that's the problem. So the only reason I think the state and it's up to the court. Obviously, I don't agree with the lower end. I agree we have to know where he is, because if we rely on him to do it, he ain't gonna come. And he's not gonna report. So we need to do the maximum of 10 years that we will know where he's at for those 10 years. That's the only way we can be safe.
Thank you, Mr. Hoffbauer. So, Mr. Arseno, I noticed the same thing that Mr. Hoffbauer did in your version when you talked to the probation officer. It says, I stopped going up there because when I went to court, the attorney told you were signing for 2 years, TDC. He didn't tell me anything about the registration part. You didn't say that?
No, ma'am. I did say that.
Okay, so when you were in court, I looked it up to make sure that we didn't miss something and that you weren't told about it. When you were in court with Mr. West, he went over with you the sex offender registration admonishment, and that's your signature right there, right?
Yes, ma'am.
Okay.
But he didn't explain nothing to me.
But you were told by him and by me that you had to register, and you obviously knew you had to register because you went and registered the first time. So saying you didn't know you had to register when you actually registered doesn't make much
I
sense.
went from Judge Stevenson. What is it?
No, you went and registered at the Beaumont Police Department. You went on July 20th of 2023 for your initial registration as a sex offender.
Yes, ma'am.
So you did know you have to register because you went and did it. You just didn't do it after that.
Yes, ma'am.
Okay. All right, so I'm going to find that you entered your plea of guilty, and also, in addition to all of that, just so everybody's on the same page, this is your 8th felony offense. You have 7 prior felony offenses going back to 97, where you got a probation, got revoked, got 5 years in prison. You've been to state jail, looks like twice or 3 times. You went to prison again in 07, or actually that one ended up in 10 for 3 years. You went to prison in 16 for 4 years for an ag assault with a deadly weapon, and then you went for 2 years on that sexual assault case. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirement. I'm going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. LeBlanc. All right, good luck to you, sir. You can go back with the bailiff.
Thank you.
What we've just witnessed is a clear example of how repeated sex offender registration violations and probation breaches are handled in Texas courts. Lenton Arseno, with a lengthy criminal history including multiple felony offenses, failed to meet the requirements set by the court, and Judge Raquel West enforced accountability without compromise. His repeated defiance highlights the serious consequences of ignoring court orders and failing to comply with probation rules. As the courtroom concludes for Lenton Arseno, showing the serious consequences of repeated sex offender registration violations and probation breaches, the focus shifts to another defendant facing the court's scrutiny. Mr. Bley now appears for multiple probation violations and a new charge of possession of a controlled substance, with Judge Raquel West presiding and ensuring that the law addresses every infraction decisively. Despite prior opportunities under probation, repeated failures to comply with court orders and legal obligations have brought him back before the court. The pre-sentence report details missed appointments, substance use violations, and other breaches of probation conditions, highlighting how seriously Texas courts enforce the law and maintain public safety.
Nope, I'm just going to go back and I'm going to just rescind everything that we did at the previous hearing, and that way we start fresh from this hearing and there's no mistake on what everyone's agreement is and what he's pleading true to, and we'll do all of that today. So will he waive the formal reading of the motion and the indictment?
He will.
The motions. Okay. Mr. Byerly, in cause number 18-28800, I have a first amended motion to revoke your unadjudicated probation. It shows that you were placed on probation May 13th of 2019 for the offense of violation of a protective order. That's a 3rd-degree felony, and that was a 10-year deferred probation. Is that correct?
Correct.
And then in cause number 18-29063, I also have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 13th of 2019, also for violation of a protective order, a third-degree felony, and that was also a 10-year deferred probation. Is that also correct?
Yes.
And so it alleges that you violated your probation, and y'all are going to go,
1, 2, 3, 4, and 6.
okay. The new offense that he's about to plead is the possession, right?
Correct, that should be number 6.
That's 5.
Oh,
6 is that he possessed it. I mean, but 5 is committed the offense. So that would make
I'm
sense.
sorry, they're different numbers in each one.
Oh,
One is 6 and
great.
one is 5.
I love that when that happens.
If you want to amend, Judge, we'll go.
No, it's okay. I have to do, it's the numbers are the numbers. Okay. Count 1 in each of these cases alleges that you violated your probation by committing the offense of assault April 21st of 2025. And is that true or not true?
True.
And then count 2 alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates in each case. Is that true or not true?
True.
2. And then count 3 alleges that you failed to provide verification of attending the JCDI program. Is that true or not true?
True.
And that's in each case as well. Count 4 in each case alleges that you failed to abstain from the use of any and all intoxicating substances, and that you tested positive for alcohol April 15th of 2025. Is that true or not true?
True.
And that's also in both cases. Count 5 in cause number 18-29063, and count 6 in cause number 18-28800 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. Is that true or not true?
True.
Is that enough for everybody?
Yes, Judge.
Sorry. I feel like I've gotten through it without messing up, but if I keep going on the different numbers. All right. Did you enter your pleas of true in each of those cases freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
In both of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
I understand.
State tenders number 1 in each of those cases.
No objection, it's 1.
It's admitted in each of those cases. Is there any evidence that Mr. Byerly is not competent?
No, Your Honor.
All right, Mr. Byerly, in each of those motion to revoke your unadjudicated probation cases, I am going to find that you entered your pleas of true freely and voluntarily. In cause number 18-29063, find counts 1, 2, 3, 4, and 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of violation of a protective order, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 18-28800, find counts 1, 2, 3, 4, and 6 true, find sufficient evidence to find you guilty, and at this time find you guilty of violation of a protective order. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Bless you. Give me just a second now. Okay, now, Mr. Byerly, in cause number 25, DCCR 0943, you're charged by indictment with a third-degree felony offense of possession of a controlled substance from May 29th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? In that case, I also have here on the computer some documents that have your signature on them. Did you go over these also with Mr. Burbank?
Yes, ma'am.
And do you fully understand them? And you understand if I follow this agreement, you will also be waiving or giving up any right to appeal.
Yes.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one in that
No
case.
objection.
It's admitted. Mr. Byerly, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of this plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will all run concurrently, which means together at the same time. I have handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, sir. Thank y'all. Thanks for your patience for me getting through that. Okay.
What we've just witnessed is a full display of judicial accountability. Mr. Bley, facing multiple probation violations, including failing to attend required meetings, testing positive for controlled substances, and otherwise ignoring court orders, was held fully accountable by Judge Raquel West. On top of these probation breaches, he committed a new offense of possession of a controlled substance, demonstrating blatant disregard for the law. Judge Raquel West reviewed all evidence, including probation reports, substance test results, and prior offenses. With every fact laid out, the court determined that firm action was necessary. Mr. Bley received a sentence reflecting the seriousness of his repeated misconduct. This case demonstrates that in Texas courts, probation is not optional, and repeated violations are met with swift and decisive consequences, leaving no room for excuses or leniency.